And of course, neither of these gentlemen need introduction, but just to make sure we're on the same page, that is United States Associate Justice Clarence Thomas and Solicitor General John Sauer discussing the need and the introduction of universal injunctions. Now, another person that doesn't need an introduction, but we'll give her one anyway, is Sarah Parshall Perry. She was the senior counsel at the United States Department of Education Office of Civil Rights. She's now vice president and legal fellow at Defending Education. Sarah Parshall Perry, welcome back. What are these guys talking about?
Yeah, so this is really interesting. You know, there was no really clear winner or loser in what I heard from oral arguments today, but it was very clear that Justice Thomas and the Chief Justice, in addition to Justice Samuel Alito, are, I think, inclined to rule for the Trump administration here. But again, we're going to the question of universal injunctions. And what Sonia Sotomayor and Justice Jackson said was that at some point, we're going to have to rule on the merits. But how is it going to come to us if every single federal court has ruled against you? Now, of course, this is a consolidation of three separate cases. And in all three of those cases from three different states, those federal judges issued nationwide injunctions saying the rule is patently unconstitutional on its face. We are going to prevent its enforcement against anyone in the country. And what the Trump administration has argued is, listen, you've indicated to us that you are definitely sort of looking with a critical view toward universal injunctions. And the fact that Justice Thomas said that, that was one of the lines that stood out to me. In other words, we don't really need universal injunctions because it is our force of habit to only try cases and controversies in front of us. And that means parties who are actually injured, actually impacted, and in front of the court to be rightly redressed in their grievances. So Roberts, Alito, I think Thomas all seemed inclined to find for the Trump administration on this, but it really goes to the question of, can the Supreme Court find an alternative theory of relief for all of these individuals? In other words, every individual in the country to whom this particular executive order applies, which, by the way, Rich, and you sort of hinted at this, this is the Trump administration, their consistency in the view of 1900s jurisprudence and the 14th Amendment's drafting itself is very clear to me. It's clear to be historically supported. They are not taking a perspective on this that is off the wall or is unconstitutional, but this goes to the very discrete question. And so what they've argued is, listen, get rid of universal injunctions. One single judge does not have the authority to bind everyone in the country, even parties to which are not present in the lawsuit. And instead, you could certify what's called a class action under the federal rules of civil procedure. So John Sauer, the SG, was arguing, take this alternative theory. And Justice Jackson, Sotomayor, and Kagan especially, who was highly critical and went on a bit of a diatribe about, you've lost every single time. We will have to get to the merits, and you've only handed us a procedural issue. We can't possibly get to that point if all of the judges keep ruling against you. So the alternative theory of class action certification is what the administration is advancing. I think it's solidly based in law, but there were no real clear winners and losers.
Sarah Parshall Perry, let's play this out. So if the legal strategy that the Solicitor General is pursuing is viable and they're able to get certified for class action, how does that play out moving forward? I heard another exchange, and I wish I could play it for the audience and for you, of Chief Justice Roberts and Solicitor General Sauer going at it about the particular point of how do you make it work? Same question I'm asking is, what does it look like moving forward? And the answer wasn't very clear as to, I think the answer the Solicitor General gave was just like any other kid that's born in the United States who's not going to be a citizen, we would handle it that way, the way we currently handle it, just it wouldn't be assumed. And that made sense to me, although simplistic, it made a lot of sense. How would that work with this class action moving forward and the executive order?
So that's a great question. Let's say that they say that this is an opportunity. You can certify a class. That's how these individual plaintiffs can get relief. They buy the government's theory. They get kicked back down to the trial court. The trial court ruling is overturned, and now you're back to the drawing board. You might have an opportunity to amend the complaint that you've already filed. I'm talking about the plaintiff's bar here, representing the illegal immigrants. Or if you're sort of a savvy ACLU attorney, you find another favorable district court in which you file a new lawsuit with an entire class of individuals, perhaps hundreds, perhaps thousands. It has to be a class of a specific size for the Supreme Court to be able to adjudicate relief for all of them meaningfully. But sometimes in these class action lawsuits, Rich, as you know, we're seeing thousands of individuals who are impacted. That is not beyond the pale. So individuals here who are directly impacted by this executive order have an opportunity to go back to the drawing board in another federal court and get relief because they're certified as a portion of a class. I don't think that's beyond the pale. I think the three conservative justices certainly indicate that that was an option. As Justice Clarence Thomas said, listen, we may do without these universal injunctions until the 1960s. This is a recent iteration, and even Justice Neil Gorsuch himself, in some dicta for related opinions that have been issued in the last two terms, has said that they are unconstitutional, and at some point the Supreme Court will have to consider them. That's exactly what they did today.
Outstanding analysis, Sarah Parshall Perry. And what else should we be apprised of? I guess, what else are you following in the legal world?
Well, we've actually seen quite a bit of high-profile litigation. In fact, every time I think that they weren't going to take another hot-button issue, they took another hot-button issue. We've already heard oral arguments in the state Medicaid challenge to funding of abortion in the state of South Carolina. We've seen Corn and the First Amendment in National Free Speech Coalition versus Pacton, whether or not you have a right as a state to require porn distributors to require age verification so that you could protect minors. Pretty commonsensical issue, but it goes to state power, it goes to the free speech doctrine of the First Amendment, and it goes to tech privacy. So big issues there. I'm most fascinated by the oral arguments in Mahmoud versus Taylor, which we just heard about 2.5 weeks ago. That is, of course, the case being brought by a coalition of religious parents who all sued Montgomery County Public Schools because their 5, 6, and 7-year-olds were inculcated, were instructed, were given curricular inclusions on LGBTQIA themes. In fact, one of the books that was designed to, quote, increase phonetic capability, it was a picture book, and it was called Pride Puppy. And they were asked to identify things like the trans flag, someone wearing leather, and an individual they believed was non-binary.
This is, you said 5, 6, and 7-year-olds?
5, 6, and 7-year-olds in Montgomery County Public Schools. They are Rich, a traditional bad actor, one of the most liberal school districts in the country, sort of ground zero. They and Fairfax County Public Schools in Virginia are both sort of ground zero for gender identity in public schools. Those parents, and they were Muslim, they were Orthodox, they were Catholic, they were Pentecostal, they were Jewish, all came to the Supreme Court. They said the same thing. You teaching this information to our children without our opportunity to opt out is a violation of our right to direct the religious upbringing of our children. They're hearing one thing at home. They're hearing something completely different when they go to school. And after all, what is a child's next obvious authority figure but their teacher? So these are children who are being told that men and women are distinct. They are immutably biologically separate from one another. And then at 5, they're being told to identify drag queens, pride parades, and transgender flags. That's the best way I know not only to confuse a young child, but when they eliminated the opt-out right, to show their hand and indicate, listen, it really is about pushing gender identity. In fact, they had an opt-out right, and Rich, they eliminated it without public notice or comments from the parents who were affected. They were asked why by the justices, specifically Justice Alito, and they said, well, it became unfeasible because there were so many opt-outs. And all they had to say, and I have to tell you, even Justice Elena Kagan said, I think even non-religious parents are going to have objections to this material based on its inappropriateness for children of a certain age. So she may actually be the swing vote in this case. It is going to be a straightforward application, I think, of a case from the 70s called Wisconsin versus Yoder. And that was a case in which the Supreme Court struck down a state law requiring mandatory education past the age of 8th grade. And the Amish said, it is part of our faith tradition that our 8th grade young men come home, they conclude their education, and then they help us build our agrarian communities and worship in the way that we want to worship. And the Supreme Court said, you know what, you're right. It is your fundamental right to direct the religious education and upbringing of your children. And that goes in a public school context as much as a private school context, as much as at home. I think this is going to be a slam dunk for the parents. I'm very hopeful, but based on the fact it wasn't heard until April 22nd or so, we are probably not going to see this until the end of the term. The last one, and Rich, you and I know have talked about this, the big gender medicine case, and I'm using medicine in air quotes here, the state-affirming medical ban on so-called gender-affirming care for minors under the age of 19. Coming out of the state of Tennessee, this was the last case to be argued in December. So that means from the December sitting, and now we are seeing the last of the December opinions roll out. I would not be surprised if we actually get an answer on whether or not those state bans are constitutional within the next few weeks.
Wow. That's a lot to lay on us, Sarah Parshall Perry. Folks, make sure you follow her at Sarah P. Perry on X. And Sarah, let everybody know where to, to check in with all the work you're doing, your website.
Definitely check us out at defendinged.org, and we are filing multiple federal civil rights complaints. We are about to launch a national civil rights lawsuit. I can't wait to share that with you in the next few weeks. And we are doing really, really heavy lifting. We want education to be value neutral and high quality for every child in America, no matter who they are.
Amen to that. Sarah Parshall Perry. Make sure you check her out, defendinged.org. Sarah P. Perry on X. You are a gentlewoman, a scholar, and a patriot. Godspeed to you, and thank you so much for giving us the update.
Thanks again, Rich.